Okay, so I still remember last session we stopped at question number 3, and then we will moving forward to question number 4. So as you can see, the question is Abu claimed against Kamal for a sum of 150,000 as damages for the loss suffered in the due to Kamal's failure to deliver the goods to him. After the full trial, Sessions Court on this day found Kamal liable and ordered him to pay a sum of 98,000 to Abu. Being dissatisfied, Kamal appealed to the High Court on this date, and then the notice of appeal was served on Abu on this date. So on 20th of June, Sessions Court notified Kamal in respect of the certified copy of the notes of evidence and the certified copy of the grounds of decision. On 12th of July, Kamal filed the appeal record in the High Court and served it on Abu. The appeal record is without the memorandum of appeal in this particular form. Now, Abu intends to contend at the hearing of appeal that the judgment sum should be varied to 150,000. So the first question is, advise Abu the procedural grounds supported by decided case which he can rely on to oppose Kamal's appeal at the High Court. So I guess there might be a lot of people skip this question because first thing is the question is it's all about appeal. And then appeal, I think this is quite lucky because it is appeal to the High Court, so that you still can find the relevant order and the rules in your rules of court. However, if the appeal is concerning the appeal to the appellate courts like Court of Appeal, Federal Court, then you are really, really unlucky, but you have to memorize all the relevant rules and also the sections. Okay, so by looking at this question, anyone knows what are the grounds for Abu to challenge? Can I have your response in the group chat? Okay, I saw one answer here. Appeal record is without the memorandum of appeal. This could be one part of your answer. What else? Because the mark is allocated for 10 marks, there must be more than one objection. Okay, I guess for this, right, since the issue is concerning the appeal to the High Court, so let's flip to Order 55. Because the appeal is to the High Court, so the relevant order is purely on Order 55. So the first part, yes, Cindy, you got one part of the answer correct. Is the appeal record is without a memorandum of appeal. So before I going forward, right, I just want to make a clarification to you all. In appeal, most of the time we will concern two things: your record of appeal and then your notice of appeal. So Now the question is on your first thing is because of your appeal record. So the record of appeal actually is a bundle which consists of the documents and the evidence included in that particular bundle. So these are the bundles to support your appeal. Well, the notice of appeal actually is just serving a notice to the appellate court by telling them, now I want to make an appeal. I want to file an appeal. I want to apply. What are my grounds that supports me to file this appeal? Is everyone clear on that? All right. So because as is the notice to opponent to there is a the notice to opponent because you once you already filed into the court, then you also have to serve it to your opponent. Yes, you are correct. So everything when it is appealed to the high court, right? We are safe. We still can find in order 55. So let's flip to order 55 because since Cindy has already mentioned that appeal record. So the relevant order is on the order 55 and rule 4. Let's see. So what should be contained in your record of appeal? The record of appeal, you have to include the relevant pleadings, the notes of evidence, the ground of judgment, memorandum of appeal, decision. So based on the fact, you did what did he miss out is that, okay, there is no memorandum of appeal. So this has contravened order 55 rule 4. So that this is how are you going to structure your answer. You have to explicitly quote this order and rules by telling the examiner that, okay, I have noticed one thing missed out. Okay, now this is my objection. Okay, so we save for one objection first. Now the second thing is, you see, this is the hints by looking into the question. Because you see, there are few dates here. Okay? Sorry, I heard someone is asking me a question. Is that? All right, Eunice, do you have any answer? Do you have any question to ask me? All right. Okay, so you see, as we can see, here are the hints. Today, the full trial is on this date. Okay, so he made an appeal on this date. So the time frame will be another issue. So the time frame as given in order 55 rule 2 is that you must file your appeal within 14 days. The 14, how is the calculation works? The calculation of the 14 days is from the date of decision. So you see, the date of decision is on this date. So by right, it should be 14 days counting from this particular day. However, he has late filing because it has around 1 month. Yes, it's about 1 month. He filed the notice of appeal. So this is another issue. Now, since we are here now, I'm going to teach you all. I will try to suggest you all how to outline your answer in a structured way. So now, because you advise Abu, what are the procedural grounds that he can rely on for the purpose to oppose Kamal's appeal? So the first thing is you already identified the issues, right? So your introduction is to tell the examiner how to advise Abu. There are the procedural grounds, the general statement. So when it comes to the second one, you have to use a subheading. First objection, contents of record of appeal. So because we just found out that we just found it out. Order 55, Rule 4, what are the documents have to be included in record of appeal? And apparently, uh, memorandum of appeal, it has to be contained. As we can see, the wording, you see, for Order 55, Rule 4, the the record shall contain copies of, yes, memorandum of appeal. The reason why I want to emphasize on this point is when you see the wording shall, I think I have said it earlier, shall in the statute carries a heavier weight than must. So it means a mandatory requirement on the fact that Kamal has failed to include the memorandum of appeal. So he has contravened Order 55, Rule 4. This is our first objection. Now, the second objection is on the timeline to file the notice of appeal. As we can see from uh, as we can see from Order 55, Rule 2, there is also another wording shall be brought by giving notice of appeal within 14 days from the date of decision. So based on the fact that Kamal has failed to comply on these two rules under Order 55, these are the objections that uh, Abu can rely on to oppose the appeal filed by Kamal. And for your information, the time to file notice of appeal, there is a case named as Ivory Glove. It's quite recent because the year is on 2023. So I will share the suggested answer in the group later so you all can have a look. Okay? All right, so we move to the second question. Whether Abu can argue on the hearing of appeal that the judgment sums should be varied to 150,000. So um now this come back to another technical part because previously when I was giving you teaching you all what is the appeal meaning, right? Now the reason why I think this is quite a technical part is because now we want to know what Abu wants. He wants to reverse the judgment. Okay. So at the time he wants to vary the judgment. Who is Abu? Now you see Abu, he wants to he wants to appeal. Is he able to do so? Yes, he is, because he is an appellant in the appeal action. So right now, on this time, I think the question is asking during the appeal whether he can argue that. Does anyone have your answer? Sorry, I think I uh I think I made a mistake. He is the respondent because Kamal appealed, so that he is the respondent. So just want to check with you. Just want to ask you all, do you all have any answer whether he can do so as a respondent? Okay, thank you for highlighting the cross appeal. Okay, just for you all, this question to me is quite difficult also because I also spent quite some time to figure it out what is the notice of a cross appeal. So, um, notice of cross appeal, right? Actually, you are admitting into the decision given by the judge. You are just trying to vary a bit, like partially lah, not the entire thing. Now you are trying to reverse it back to 150,000, which is the original position, right? Because the judgment sum is awarded at 98,000. So if Abu wants to file a notice of cross appeal, he unlikely that he can do so because I think this case has been shared earlier. It's the case of Kabushiki. You cannot use the notice of cross appeal to reverse the entire judgment, but you can vary partially. So that from what I so that my answer here is that by looking into the fact, right, unlikely that he can do so. But since it is allocated at 8 marks, so we have to put it in this way. So the first thing is we must explain to the examiner what is the function of notice of cross appeal. So the the answer here, once you have explain to the examiner what is the function of notice of cross appeal. So I will share to you all later what is the function of notice of cross appeal because I have typed my answer, but the answer is quite short lah. So just like briefly telling you all, the notice of cross appeal, the function is to is when you are chat when the respondent wants to respond to the appellant's uh submission, it's something like that. But the thing is, the notice of cross appeal cannot be used to vary the entire judgment. And then there is a time frame. It is given in Order 55 Rule 8 that the timeline to serve the notice of cross appeal is within 14 days. Is that okay for everyone? Okay, I saw the question. I think he is just disputing partially. Okay, never mind. We leave it on hold first because the way how I understand the question is instead of paying a sum of 898, he wants to get the 150,000 back. That is why I say this is the entire judgment now. Okay. So never mind, I will check with Dr. Chi and them. So I will revert to you all as soon as possible. Is that okay? Okay, now question B. Kamal does not want Abu to execute the judgment until the appeal at the High Court is disposed. Advise Kamal on the procedure and the legal principles in relation to this matter. So anyone, you may respond in the chat group, in the group chat, sorry. Okay, since this question you see, the keyword is here. He does not want the he does not want someone to execute the judgment until the appeal is being disposed. Okay, state of execution, correct, but this is allocated for 7 marks. So this is how I'm going to structure. First thing is you must tell the examiner what is a state of execution. The state of execution basically is that you are temporarily suspending a party to execute or enforce the judgment until the appeal is being disposed. So this is the key word. And what are the procedures? I will tell you all later, so that when your general description of state of execution is explained, so the next step, what are the principles that the court will grant for state of execution? So the landmark case is Serangoon Garden, because the judge in the case quoted that the parties shall not be deprived by the fruits of litigation, so that in that case, the court has used a special circumstances test to determine whether the state of execution should be granted. Then later on, to define what amounts to a special circumstance, in the case of Leong Po Shi, the court has defined the special circumstance as uncommon, unusual, and exceptional. Nevertheless, in the case of what Si Tiao Guan, the case is Si Tiao Guan, Dato Sri Si Tiao Guan, I forgot, if I'm not mistaken, the nugatory principle, where the successful appeal will render a nugatory if the state of execution is not granted. So when you already outline all these concepts into your answer, right, then you can put also because because Cindy has mentioned the case of MGG Pillai, the case is actually saying that merits in the appeal shall not be a ground to suffice for applying the state of execution. This is a contradicting case. So when you already outline all this, you can close your answer already, because this is more than enough. Okay? Does anyone has question to ask on this question? Yeah, but last but not least, since this is appeal to the High Court, once you already explain all the relevant principles, you must also include Order 55 Rule 6, because this is appeal to the High Court, and you can find it in your rules of court, where the procedure on how to apply for the state of execution Order 55 Rule 16. Sorry, my fault on this. So now we come to question number 5. Poon filed a writ action against 3 defendants. Okay. First one, registered office in Putrajaya. Second one is a partnership, and the principal office is at Klang. Third one is a society registered under Societies Act 1966 with a clubhouse in PJ. The writ served to PQR Sendirian Berhad is by sending an AR registered post to the registered office. On the second one, leaving a copy of the writ with the receptionist in Klang, and the society leaving a copy at the clubhouse in PJ. All 3 defendants have failed to enter appearance. Okay. Now, based on the above facts, advise whether the writ served on all 3 defendants are valid. I think this one you all must have attempt, right? So can I have your answer in the group chat? Okay, when we see this kind of questions, right, because there are three parties, so that is allocated for 9 marks, so that using the subheading will suffice. So the first one, you see, Sendirian Berhad. Sendirian Berhad is a company. So look, flip to order 62 and rule 4, sub 1, then you will find your answer whether the service is valid. So when looking into order 62 rule 4 sub 1, the service of read is leaving a copy in the registered office, registered post, or handle a copy to the secretary or any director. So you see, AR registered post. Is that valid? Arguably, it's not valid. Do you all know what is the difference between an AR registered post and a registered post or not? An AR registered post will have the acknowledgement, will have the acknowledge card. So it's a yellow piece of card by saying who has received the document. But the registered post is just a sticker with a tracking number so that you can trace where is the document being delivered. So on the fact this is delivered by using AR registered post, arguably only it's not valid. Okay. Now the second one, Ace Trader is a partnership, so it is served at the receptionist. Is that valid? You may flip to order 77 and rule 3. Then you can find your answer. So looking at order 77, rule 3, it has to be served on individual partner or any person having control of the business. So when you serve on the receptionist, I don't think so it is valid, because uh, looking into the wordings, there must be someone having control of business or individual partner. Apparently, the receptionist doesn't qualify to any single of this scope lah. So I would say the service is bad also. Now the third one, PJ Old Boy Society. Looking into section 62 of your Societies Act 1966, the service is on the public officer or the office bearer. So the public officer is, you have to refer it to your question number 1. It shows that who is the registered officer, which means that the public officer is that someone who is who is appeared on the ROS. The ROS is the registrar of the society. That's saying who is the officer in charge of this society. But here you see, it's leaving a copy at the clubhouse. There is no one. So apparently this has contravened. Then the office bearer is that the persons holding a position in that particular society, like the chairman, secretary, your treasurer, and other committees. So based on the fact it has contravened to the to section 62 of your Societies Act. So by outlining your answer, you have to differentiate it in the subheadings. Your first subheading is on PQR Sendirian Berhad. So you say, oh, on this rule, what has to be done? And based on the fact, okay, arguably not valid because AR registered post is different from registered post. Now, the second one, ace traders, because ace trader, they serve it on the receptionist, which has contravened Order 77. So not valid as well. Then the third one is the PJ Old Boy Society. And since the fact that it is being left in the clubhouse, so it's also not valid. Is that okay for everyone? Once you have already concluded all three subheadings, then you can proceed to the next question. Is that okay? Okay, now we move to, is AR registered post safer than registered post? Technically, you are correct. Because AR registered post, as I said, there is an acknowledgement card. So that this is how AR registered post works. On the letterhead at the front side, there will be a yellow sticker by giving you the tracking number. Then at the back there, you will have to stick a piece of card. So whoever has received and acknowledged the letter, they have to include the name and also their details so that you will get a return of that particular card. So you will be able to say that you'll be able to know who has received the document. Is that okay? Okay, so now we move to question B. Hassan received medical treatment in the private hospital where he was prescribed a drug which was newly introduced by pharmaceutical company, and now he was adversely affected by the drug and the condition is worsened. The doctor who treated him have absolved themselves of liability and laid the blame for his condition on the drug. Now Hassan asked the pharmaceutical company for more details about the drug and the effects on the patients. The pharmaceutical company has refused to provide any info. Now Hassan wants more information on the drug that was prescribed to him in order to determine if it was the hospital or pharmaceutical company that was liable for his present condition. Advised Hassan on the procedures he should adopt to obtain the necessary document and information in order to determine who he should sue. So, anyone knows the answer? Yes, it is Order 24 Rule 7A, discovery. The topic is on discovery. So that if we are going to start answering, right, the first thing is we must tell the examiner the general rule. So the general rule is provided in the case of Norwich Pharmacare. I will put in this chat box, yeah. So in this case, the court held that you cannot apply for discovery against a stranger unless you want to know the identity of the stranger. Okay? So now, based on the fact he wants to know who he should sue, therefore, Order 24 Rule 7A applies. So after you explain the general rule, right? Now we come to the procedural part. The procedural part is provided in Order 24, Rule 7A, Sub 1. He has to file the OS supported by affidavit, okay? And the contents of the affidavit is provided in Rule 7A, Sub 3 of your Rules of Court. So you have to itemize it out lah. What should be included in the affidavit? Thereafter, you have to comply with the timeline of service as provided in Rule 7A and Sub 4. Then the court will fix a date for hearing and determine whether the discovery action is necessary as given under Order 24, Rule 8. Is everyone clear? Okay, the reason why I'm telling you all this because now you cannot simply tell the examiner that, oh, the procedure, without explaining why you are coming that, where do you coming from? You must tell the examiner, oh, the entire fact is surrounding the issue of discovery. And what is discovery? So you explain to the examiner you want to pursue them, or the reason why I say discovery is because of this and that. Once you already given your introduction, then you can move forward to the procedure. The procedure is how do you apply for discovery? This is the first part. Then what should be contained in the so-called affidavit? That is your part 2. Then after everything is done, you must comply to your service. That is part 3. Then the part 4 is the court will fix a date for hearing and determine whether order for discovery will be granted. This is how are you going to structure your answer. So you will let the examiner to see, oh, I'm not plucking everything from the sky. This is how I come along. Is that okay? All right. So we move to question C. ABC filed a writ action against 3 defendants. The prayer in the statement of claim are follows. The first one, declaration, order for specific performance, and general damages. I think this one was quite repetitive. Okay. Second one, order for vacant possession of property. Then the third one, order for rental arrears. Now, all 3 defendants retain a solicitor who enter appearance for them. However, soon after filing the appearance, the solicitor formally discharged himself as a solicitor for all defendants. The period for filing the defense has lapsed and they have not appointed a replacement solicitor. Now ABC wants to enter a default judgment against all the defendants. Advise ABC on the procedure to be adopted in respect of each defendant. Okay. Anyone? Okay, I think this question is also very, very lenient enough because they have tell you all 3 defendants ma. So we look into the defendants one by one. So you see the declaration for the first for the claim for against the first defendant is declaration, specific performance, and general damages. So for the first one, right, general damages is an unliquidated damages. Yes, it could be, but the problem is whether they can claim for declaration and specific performance. Now let's flip to order 13 Rule 6. Have you all seen that? You cannot claim you cannot claim for anything not mentioned from Rule 1 to 4. What is Rule 1 to 4? Rule 1 is liquidated. Rule 2 is unliquidated. Third one is the detenue, which means that you are detention of movable property. Fourth one is on immovable property. So any claim other than this are not allowed to be claimed. That's why by looking into the fact that ABC wants to claim for declaration and order for specific performance, these are not allowed. However, general damages may be allowed. This is how are you going about this question. So you put into your first subheading against the first defendant. This is first subheading. On the fact ABC is claiming for declaration, specific performance, and general damages. Person to Order 13 and Rule 6, declaration and order and specific performance are not allowed to be claimed, are not allowed to enter into judgment in default, unlikely that they can do so. However, general damages is given in Order 13 Rule 2. He may be enter a default judgment against the first defendant for this only. So you have to write it specifically what can be entered against the first defendant, what kind of judgment can be entered. All right. Then now we move to the second defendant, vacant possession. Vacant possession, as I say, right? Vacant possession is given under Rule 4, possession of immovable property. So you can write it down there. Your Rule 4. What can you this can be entered under Rule 4, Order 13 Rule 4. Now, arrears of rental on the third defendant. This one is quite easy because it is liquidated damages. So under Order 13 and Rule 1, this can be entered against the third defendant. And you may close your answer and move to the next question. Is everyone okay on this? The problem is on the first defendant, because I think this was on last year. I think they have asked the similar question on whether the default judgment can enter against the defendant who is claiming these three items. Is everyone okay? Okay, let's move to question number 6. Question number 6 is also quite headache lah. Sammy was a government officer attached to MOF since 16th of September 2001. He had a dispute with superior, was dismissed from government service by way of Gazette notification dated on this particular date. On this date, Sammy filed a writ of summons and statement of claim against Government of Malaysia, applying to set aside the dismissal for damages due to wrongful dismissal. Now, the senior federal counsel acting for the Government of Malaysia contended that Sammy should commence a judicial review application instead by first asking for leave of court, and hence action should be struck out summarily. Now he comes to you and advise the following: whether the objection from senior federal counsel on the writ action ought to be struck out. This is 13 marks question. Do you all have any clue on how to go about? Okay, correct. Leave should be first obtained. But on from the issue, right? This is 13 marks question. We must write some objections lah. Okay, so for the first one, we want to see what is the cause of action. The cause of action is unfair dismissal by under a government body. So apparently, whether he has the cause of action against the government. Now, cause of action is actually very, very important because the cause of action is essentially to determine whether you have a valid case against the particular party. So from the fact that this is, I know some of you all might have confused whether he can sue the government. Okay? Now, the question here why the question here why the examiner set this type of question is that they are trying to frame you to show you that this is the negligence of the government officer. But apparently it is not because it is a decision made by the government body. And how to explicitly giving you all a clearer image on the negligence by the government body is that, like the recent case, the manhole. Then the second case is that the tree branch fall on the road and then hit someone's car. Yes, these are the cases that we can show show that those are the negligence by government body. But apparently, this has nothing to do with the negligence and purely a decision made by the particular government body. So this is actually should be done by way of judicial review, because judicial review can be explained as any person who is adversely affected due to a decision making by a public authority. So we see from the fact he was dismissed from the government service by way of a gazette notification. So this is a decision made by the government body. This has matched with the criteria of judicial review. So is everyone understand, or should I elaborate further? Okay, so this will be my first point, because the reason why being is that he was unfairly dismissed. So this apparently is a decision made by that particular government body. Therefore, it has to be done by way of judicial review. This is my first objection. Then the second objection is striking out of the statement of claim, striking out of pleading. Because the reason why when you file a reaction, there must be along with the pleading, which is statement of claim by SEMI to the government of Malaysia. Now, in Order 18 Rule 19, the conditions that you can strike out a pleading is because, firstly, no reasonable cause of action. Secondly, scandalous, vexatious, and frivolous claim. Third one, abuse the process of the court. So based on the fact he has no reasonable cause of action where it should be done by way of judicial review. Therefore, these are the objection raised by senior federal counsels. The senior federal counsel are sustainable. But you can also elaborate further on the part one, because the cause of action part, you have to differentiate by telling the examiner that you will have a very clear mind that what is the difference between a writ action and the judicial review. Because a writ action, as we can find in Order 5, Rule 2, there must be a substantial dispute to the facts. Based on here, we cannot find any substantial dispute to the facts. That's why the writ action should not be commenced. And then, on the other hand, judicial review, as provided in the case of Ahmad Jeffrey, any person who is adversely affected by the decision made by public authority who was exercising his public duty can be brought an action by way of a judicial review. You want to make a differentiation between a writ action and a judicial review in your first objection. This is your first objection, your first point, sorry. Your first point by telling the examiner, this is why how can the senior federal counsel can come about. Second one is whether the statement of claim can be struck out because there is no reasonable cause of action. So the pleading filed by SEMI is also can be struck out so that the entire writ action can be struck out. This is how am I going about to answer this question now. Is everyone okay? No reasonable cause of action now, because the entire thing is has nothing to do. You are not disputing. You are challenging the decision made by the government body. You are not dispute whether the government body has the right to do so. You are just dissatisfied with it is unfair dismissal, but the problem is you have gone by way of a wrong action lah. I mean, yeah, just because you have commenced a wrong action in the beginning, so that whatever from the foundation is wrong will carry until the end of the day. Okay, that is the reason why I say that should not be a writ action, but a judicial review instead. So when you already establish judicial review should be the appropriate action, then your entire writ action is struck out. But you also have to tell them, oh, I know writ has to become along with the statement of claim. So might as well strike out the statement of claim. Is that okay? Okay, now we move forward. The procedure that he should adopt in the judicial review application as contended by the senior federal counsel. Okay, inshallah, because everything is, you have to go to Order 53, Rule 3, and Rule 2. What is included in Order 53, Rule 3 is how to apply for the leave of court. Okay. then the Order 53 Rule 2 is your subsequent application for the judicial review. Because the thing is, you must make sure that the leave of court is obtained before you want to apply for judicial review. Is that okay? Okay, once you already outline the Order 53 and Rule 3, then you can further write on the Order 53 and Rule 2. So these are the relevant procedures. But also one thing, okay, I guess he wouldn't get caught lah. He will get caught because you see, notification dated on this date, January 30th. But you see, when he filed the action, because as given in Order 53 Rule 3, the time frame shall be in 3 months. This is provided in Rule 3 sub 6. You must do it within the 3 months time. That is why when you see there is a date contained in the question, you must highlight because it could be part of your answer. Okay? Now we look into, is there any questions? Okay. Now, the sub C, whether he can apply for damages in judicial review application. So what do you all think? Whether he can claim? Yes, it can be claimed because this is given in your Order 53 Rule 5 sub 1. I just flip to that rules, so you can see what the damages if included in the statement of support when during his application for leave. So it is allowed. Okay? Does anyone have questions? Okay. 7A. Amil entered into a S&P with Manap to purchase the house in Banting. Amil paid a deposit and is in the process of applying for a bank loan to finance the purchase of the house. Unknown to him, Manap subsequently accepted an offer from Chong to sell the house at a higher price and further executed S&P with Chong after receiving a deposit from Chong. Manap then changed his mind and refused to proceed with the sale. And then Chong filed a writ action against Manap seeking specific performance. Now, Amir has become aware of the subsequent sales S&P between Manap and Chong, as well as the writ action filed by Chong. Now, advise Amir on the procedure which he should adopt if he wants to safeguard his interest in the property. So, does anyone know what is the question is asking about? There's a keyword here already. Anyone wants to try? Injunction. I don't think so. Because the keyword is here. Wants to safeguard. Because you see, injunction is that when you see the action is before anything turn worse. Now the situation is becoming worse because Mana and Chong has been in a civil action. So the appropriate thing here is intervener. Is that okay? Because the problem is here, the keyword, to safeguard the interest in the property, so that anyhow he still can have some interest, he still can safeguard his right. So the intervener usually we are saying that when both are unknown to one person, unknown to A, B and C is suing each other in the court already. So A wants to be like a stranger lah in the action. Now he wants to know how is the case go about and what are the outcomes after the civil action. This is how an intervener proceeding comes about. Okay? So intervener proceeding is provided in Order 15 and Rule 6 of your Rules of Court. So to determine whether Amil can go for intervener proceeding, in the case of Pegang Mining, he must have legal interest, not commercial interest. So we look at this. Amil has paid a deposit. Okay, so now he is trying to because the moment when you pay a deposit means that you are technically an owner already, but subsequently someone wants to sell the house, and then now another fellows are suing each other in the court. I want to safeguard my interest. This is how the intervener proceeding works lah. Is that okay? Okay, so when we already explained the principle in Pegang Mining, then we will come to the next stage, which is how to apply for intervener proceeding. It is given in Order 32, Rule 1, Notice of Application, supported by affidavit. That is the entire answer. Is that okay? All right, I think because, okay, for on my first thought, the reason why you all think that this is an injunction is because you see someone has sold the house and then whatnot. But the problem is at the later stage. Now they are having a civil action in the court already. So you cannot use an injunction to stop the court. Hey, please don't proceed. Unless this has gone before the court. Now I already know that he is going to sell to another person. I want to stop the entire sale and purchase. Then I apply for an injunction to stop the transaction. Yes, this is how an injunction works. But now, because they are suing each other, both of them are the parties in the action. Now I want to intervene in action and go to have a knowledge on how it goes and what will happen. So the appropriate thing is intervener proceeding. Is this explanation okay for everyone, or you all need some further clarification? All right. So we move to question B. Vendor and purchaser enter into sale and purchase of a piece of land belonging to the vendor. The vendor received a deposit of 500,000 from the purchaser upon execution of the agreement. There was a condition precedent in the agreement that consent of state authority was to be obtained, otherwise the agreement would be aborted. Now the state authority refused to grant the consent. Then the agreement was mutually terminated. The vendor has refused to refund the deposit to the purchaser. Purchaser filed the action in court to return of the deposit. Now advise the purchaser on the procedure that he should adopt to obtain a speedy judgment against the vendor. So I guess you all would know which order is concerning, right? Why do you all think it's order 14? No, it's summary judgment, yes. But summary judgment, there are few orders, namely 14, 14A, 81, and 89. So 14 is a general summary judgment, yes, but the problem is, and I'm sorry, let me itemize it one by one. 14 is basically a normal summary judgment. 14A is on question of law. 81 is on the termination of contract. You want to get back your equitable relief, such as your specific performance and the deposit being made. And then the 89 is against the squatters. So based on the fact here, all the purchaser wants is to get back the deposit, The deposit is being made to the vendor. So based on the fact, 81 is more appropriate. You may flip to order 81 and rule 1. Sub 1, it says the the action begun by Reed endorsing a claim for specific performance of an agreement for the sale and for the rescission of agreement, forfeiture, or any deposit made. This is why I'm using 81. Because how to use order 14 is basically goods and deliver sold. And somehow is when someone some of the time is that there's a clear-cut case that the defendant has no defense. But in this question, there is a slightly different because everything is based on a termination of contract. That is why Order 81 is more appropriate. Is that okay? All right, I think this one sometime you see because there has no defense and then it's very clear cut, then you all might get into confused whether I should use order 14 or 81. But then now it's based on the contract, order 81 is the correct answer. Okay, now we move to the last question of tonight. A defendant failed to comply with the direction given by the judge during CM case management. Judge issue an unless order whereby the defense would be struck off and the judgment enter for the plaintiff if the defendant did not comply with the CM direction by next case management date. Defendant solicitor finalized all the case management direction but was unable to file them on time as he had fallen ill. On the case management date, the judge struck off the defense and entered the judgment for the plaintiff on account of the defendant's default of the unless order. Advise the defendant on the procedures he should adopt to set aside the judgment. Okay, so can I have your answer again? Order 34 will be the essential parts of your answer. Um, but may I know the particular rules that you are going to use? Okay, I think rarely you can see this kind of question. because the thing is entirely on pre-trial case management. So you have to tell the examiner first thing is what is going to happen during the pre-trial case management. So given in Order 34 and Rule 2, the court may direct the parties to attend a pre-trial case management, and we use in the short form PTCM, so that the PTCM means that now the judge want to ask the parties to attend for case management on to discuss what are the things that they have to comply between the parties. So when the parties attend the PTCM, the court will direct them, or on next date, what should you do? And what should he do? And what should you do? And what should I do? Okay. Now, these are the directions. First thing. So, given in Order 34, Rule 2 and Sub 2, the court may direct the parties to provide the informations to the court to ensure that the proceeding will be go on smoothly lah, so that they will ask you to comply the direction to follow. However, now the issue is here. Whether the judge can do so by setting aside throwing the case lah. So this is given in your Order 34, Rule 2, and Sub 3. The court may dismiss the action on either plaintiff or defendant due to the non-compliance. So on the fact that the defendant has failed to comply with the direction to file the things on time. Okay, the court may dismiss the action and enter the judgment against the plaintiff. This is given in Order 34, Rule 2 and Sub 3. However, under Order 34, Rule 2, Sub 4, if there is a good reason, the aggrieved party may apply to the court to reinstate the action, to set aside, which means that to set aside the judgment entered by the court. Now, the reason why, to see whether or not there is a good reason, this is provided in the fact he had fallen ill. We cannot suka throw someone's case when people are on ill. This is a very strong ground. So that given that the counsel is on illness, it can be set aside under Order 34, Rule 2, Sub 4, and the way how to set aside is given under Order 42 and Rule 13, as what we can see from the chat box. Because Order 42, Rule 13, usually you can see is the JID, because JID itself is not final judgment until 30 days has been lapsed. This is given in your case of re-UDOS, so that by looking into this question, how do you going to structure your answer? First thing, what is a pre-trial case management? You have to tell the examiner, you have to write out. This is your first heading. What is a pre-trial case management? Order 34, Rule 2 and Sub 1. And what will the court do? Order 34, Rule 2, Sub 2. This is your first subheading, the entire function of the PTCM. Now, the question here arising on the non-compliance. So this will be your second subheading. What can the court do when there is a non-compliance by a party in the PTCM? So this is given in Order 34, Rule 2 and Sub 3. However, there is an exception, because if you have a strong ground, then you have a very good and valid reason it can be set aside by the court as it think just. So how are you going to set aside? Order 42 and Rule 13. Is that okay? Oh, this one. Okay, does anyone have any question pertaining to this partial paper?